Welcome to The Voter's Voice, where we lay out the bills and you decide if they make sense.
Today, we're really jumping into something significant happening in California. A legislative proposal, Assembly Bill number 7, or AB7, it's stirring things up in higher education.
It really is. We're looking directly at the bill text itself, AB7, as amended in the Assembly on July 3, 2025. So it's very current.
Okay, let's unpack this. Who's behind this bill? Looks like quite a list. Assemblymember Bryan is the principal author, then principal co-authors, Assembly members Bonta, Gibson, Jackson, McKinnon, Wilson. And from the Senate side, Senators Smallwood Cuevas and Weber Pearson.
Right, and there are other co-authors too.
Yeah, Assembly members Ellewery, Kalra, Sharp Collins, and Senator Richardson, introduced back on December 2, 2024. Quite the coalition. So our mission today really is to dig into what AB7 actually says, what it means for college admissions, and crucially, the legal context. We want to give you the essentials so you can really understand what's being proposed here.
Exactly. It's about understanding the details.
Okay, so let's start with the core proposal. What is AB7 actually trying to do?
Well, fundamentally, it's looking to add a new part to the Education Code, Article 13. And the title, according to the Legislative Council's Digest, which is like the official summary, is Postsecondary Education, Admissions Preference, Descendants of Slavery.
Wow, okay. Straightforward title. That tells you a lot right there.
It certainly does. It sets the stage very clearly.
And the key phrase in the bill seems to be about considering a preference.
That's right. It states that various higher ed institutions may consider giving an admissions preference to applicants who are descendants of slavery.
May consider. That feels carefully worded, not shall or must.
Extremely carefully worded. It's not a mandate. It's permissive. It gives institutions discretion, which is probably, well, almost certainly a nod to the existing legal landscape in California. A direct mandate could face immediate court challenges.
Right. We'll definitely get into that legal side. So which institutions are we talking about? Is it just the big public universities?
No, it's actually quite broad. It covers the California State University system, the CSU, also the University of California, the UC system.
Okay.
And then it extends to independent institutions of higher education, think accredited private colleges, and also private post-secondary educational institutions, which is another category defined in the code. So public and private.
That's a pretty wide net. But you mentioned the UC. Isn't there usually a special condition for applying laws to the UC system?
Yes, exactly. You're thinking of the Dono Higher Education Act. There's a provision there that basically says a part of the act, like this proposed article, only applies to the UC if the regents of the University of California specifically pass a resolution to make it apply.
So the UC regents would have to actively vote to adopt this policy. It wouldn't just happen automatically for them.
Correct. They have that layer of autonomy they need to opt in.
That's a really important distinction. Okay, now, this leads us to something you mentioned earlier, the legal constraints. The bill itself seems to acknowledge some limitations.
It does, very explicitly. And what's fascinating here is this direct statement within the bill. It says, quote, "This subdivision shall be implemented only to the extent that it does not conflict with federal law."
Federal law, okay. But here's where it gets really interesting, isn't it? Because California has its own very strong law on this. Proposition 209, that's the state constitution, right? Prohibiting preferential treatment.
Precisely. Article 1, Section 31 of the California Constitution, Prop 209, it flat out prohibits the state from discriminating against or granting preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in public education, employment, and contracting.
So how does a bill proposing a preference based on lineage, which is tied to ancestry and historical race-based slavery, even navigate that?
Well, that's the multi-million-dollar legal question, isn't it? If we connect this to the bigger picture, the no conflict with federal law clause is key, but the conflict with state constitutional law seems pretty direct. The bill doesn't explicitly say how it overcomes Prop 209. By focusing on federal law, maybe the authors anticipate or hope for federal changes, or perhaps they believe this specific type of lineage-based preference isn't strictly prohibited by Prop 209's wording. It's legally very complex.
It sounds like they're trying to thread an incredibly fine needle, legally speaking, acknowledging the hurdles.
Definitely. It signals awareness of the legal minefield.
Okay, so given all that legal complexity, the definition of who qualifies becomes absolutely critical. You can't just vaguely say descendants of slavery if you want this to hold up. So what does this all mean? How does the bill define it?
It provides a very, very specific definition. It has to, really. It defines a descendant of slavery as, and I'm quoting again, a person who, based on lineage, is a descendant of an individual who can establish direct lineage to a person who, before 1900, was subjected to American chattel slavery.
Okay, direct lineage before 1900. That seems challenging to prove in itself, but is that it?
No, there's more. That's just the starting point. The applicant also has to show that the ancestor met at least one of 5 specific conditions related to their experience under slavery or their path to freedom.
5 conditions. Okay, this sounds really detailed. Let's walk through those.
Right. So the ancestor, the person subjected to chattel slavery before 1900, must have, number 1, was emancipated through legal or extra-legal means, including self-purchase, manumission, legislative action, military service, or judicial ruling. So various ways freedom could have been gained.
Okay, that covers a lot of ground. What's the second one?
Second, obtained freedom through gradual abolition statutes or constitutional amendments. This points to the slower state-by-state processes.
Makes sense. Third,
was classified as a fugitive from bondage under federal or state law.
Yeah.
So, someone who escaped and was legally considered a fugitive.
Like under the Fugitive Slave Acts.
Got it. Exactly. Yeah. Fourth, was deemed contraband by military authorities. This is more specific, often relating to the Civil War period.
Right, the contraband of war status.
Okay, and the fifth.
Rendered military or civic service while subject to legal restrictions based on ancestry historically associated with slavery. Acknowledging service despite ongoing legal limitations.
Wow. That is incredibly specific. Each one of those points to a distinct historical or legal status. It's not just saying was enslaved, it's detailing the circumstances surrounding their status or freedom in really granular ways.
It's remarkably granular, and that level of specificity likely serves a dual purpose. One, it tries to create a very clearly defined group, perhaps hoping that precision helps navigate the legal challenges around broad racial classifications.
And the second purpose? Well, it implicitly acknowledges the sheer complexity and diversity of experiences under and escaping chattel slavery. It's not monolithic.
But practically speaking, requiring an applicant to prove not just lineage back before 1900, but also that their ancestor fits one of these specific, often poorly documented historical categories, that seems like a monumental task.
Monumental is a good word for it. The burden of proof could be immense. Think about accessing records, genealogical research costs, the emotional labor involved in documenting potentially traumatic histories. It raises huge questions about implementation.
Yeah, absolutely. Which brings us to why really understanding this matters, why this deep dive is important for you listening.
Precisely. Bills like AB 7, they aren't just abstract legal documents. They touch on really fundamental questions. Questions about equity, about how we address historical injustice, what the role of our educational institutions should be in society. Seeing how lawmakers try to navigate these issues, balancing history, law, and social goals, gives you insight into much broader conversations happening right now.
It really does. It's a proposal that, if implemented, could genuinely reshape admissions and institutional policies. It's a specific attempt to grapple with history's legacy. Even looking at the structure, the caveats, the definitions, it tells a story about the challenges involved. So, just to quickly recap where we've landed, AB 7 proposes allowing California colleges and universities, public and private, though with a special step for UC to consider an admissions preference.
Right. A preference for applicants defined quite specifically as descendants of slavery, based on pre-1900 lineage and meeting one of 5 detailed historical criteria.
And all of this hinges on that critical condition.
Yeah.
It can only be implemented if it doesn't conflict with federal law.
Which sits alongside California's own constitutional ban on preferential treatment, creating that significant legal tension we discussed. And this raises an important question, really, for you to think about after this. Beyond the legal arguments, what might be the practical and social ripple effects of implementing a policy like this? How could defining preference based on such specific historical lineage impact diversity efforts, institutional identity, and the broader dialogue about history and opportunity today?
That's definitely something to chew on. The potential impacts, intended and unintended, are vast.
Hope you enjoyed this episode. Tune in again to make sense out of all the bills.